Good afternoon, everyone, and welcome to this Courthouse Steps webinar following last week's oral arguments in Wolford v. Lopez. My name is Libby Dickinson, and I'm an Assistant Director with the Federalist Society's Practice Groups and Networks. As a reminder, all opinions expressed are those of our speaker and not of the Federalist Society. To that point, today we're honored to be joined by Professor George Mocsary with the University of Wyoming College of Law. Professor Mocsary is also the founder and director of the Firearms Research Center. Professor Mocsary teaches and writes about agency and partnership, contracts, corporations, securities regulation, the Second Amendment, and firearms law, including the intersection of firearms law and private law. He is the co-author of Firearms Law and the Second Amendment, Regulation and Rights and Policy, the first casebook on this topic. If you have any questions throughout the webinar that pertain to the topic at hand, please submit them through Zoom's Q&A feature, also located at the bottom of your screen, not the chat, so we'll be able to access them later. With that note, I will turn things over to Professor Mocsary. Thank you so much for joining us today.
Thank you, Libby. It's always a pleasure to be here and always a pleasure to give back to the Federalist Society. As Libby said, we'll be talking today about the oral arguments in Wolford v. Lopez and some of the issues and items discussed and raised in that case. But to start us off, I'm actually going to start us way back at Heller in 2008 and what Heller said about public carry. I'll shift from there to how Heller was treated by the inferior courts to give you some important background facts. I'll talk about what Bruen did, what came next and why we have Wolford, and then what happened at Bruen oral arguments, and I'll make some references to the briefs of the parties as well. So starting with Heller in 2008, as many of you or most of you or all of you probably know, Heller was the case that said that the Second Amendment protects an individual right to keep and bear arms. Now, Heller just dealt with firearms in the home, handguns, and long guns. The long gun part is often left out, but it did say you have a right to have a functional long gun in your home. But Heller's analysis strongly implied that the Second Amendment protects the bearing of arms outside the home, and bear under Heller meant carry. Just to give you a couple of examples, it relies on 19th century case law that held that the right to bear arms mandated the legality of either concealed or open carry. It lists a number of long-standing, presumptively lawful arms-bearing regulations, including, lots of air quotes today, laws forbidding the carrying of firearms in sensitive places. That phrase becomes important. That's kind of a term of art now in this field, without sanctioning a general ban on public carry, suggesting that some regulation of arms carriage outside the home is not presumptively lawful. And there are others as well, other facets of Heller that suggest that, which we can get to in the Q&A if you're interested. Now, despite Heller's implications that the Second Amendment protects arms bearing outside the home, the judicial response to claims asserting a right to carry outside the home ranged from mild confinement of the government infringement to a may issue permitting regime. May issue means that the governmental authority issuing the carry license has discretion in whether to issue the license or not. So it may issue the license. Typically, it comes along with some kind of special need requirement saying that you have to show some special need over and above what's normal to the population. And the special need can be quite onerous. It's not enough that you live in a dangerous neighborhood or a generalized desire for self-defense isn't enough. So it ranged from mild confinement, to a may issue permitting regime to outright defiance of decades of fundamental right jurisprudence. And I'll just discuss one of those defiant cases and out of many that I think is the most defiant. The Third Circuit case of Drake v. Filco, I think is the most defiant. At issue was, New Jersey's very restrictive may issue statute. So the court first applied the two-part test. Now, the two-part test was the test that all but one circuit applied before Bruen, and it went like this. It looked at the conduct being asserted as being protected, and if as a matter of history, that fell outside the scope of the Second Amendment, the case was over, and the plaintiff lost. The rights asserting plaintiff lost. If the court found that it fell within the scope of the Second Amendment, then it applied some kind of means-end scrutiny, depending on how important the court thought the right was. And so intermediate scrutiny is typically what we got there. Um, and if you're thinking that that's kind of glaringly circular, you're right. Um, in this case, the when it got to it first said that the the public carriage fell outside the scope of the Second Amendment's protection because the justifiable need requirement was longstanding. Um, uh, Yet it didn't do anything to allow the plaintiff to rebut any presumption there. But more interestingly, the Drake majority applied what it termed intermediate scrutiny in a way that was more deferential than rational basis review. So, under intermediate scrutiny in the Third Circuit, as elsewhere, the state bears the burden of justifying its regulation. But in this case, the court relied entirely on the quote, predictive judgment of New Jersey's legislators, end quote, that limiting the issuance of carry permits would enhance public safety. Um, and that predictive judgment was based on no evidence at all, literally no evidence at all. That's a quote of the dissent. That was okay, the court said, because when New Jersey passed its statute, Heller hadn't yet declared the Second Amendment to be an individual right, so the legislature could not have been expected to gather evidence to support its law. So understand the import of this. This means that under Brown v. Board of Ed, any jurisdiction that that discriminated in its schools could continue to do so because, well, Brown v. Board of Ed hadn't been decided and hadn't declared that to be constitutional. Obergefell is another one, right? Same-sex, any state that barred same-sex marriage before Obergefell, it's okay because it didn't know that Obergefell would come along and make a declaration of unconstitutionality. And keep this logic in mind. This comes up with Justice Jackson's thinking about the black codes during oral arguments. So Drake is just, again, one example of many. Then came Bruen in 2022, and the Bruen plaintiffs challenged New York's May issue licensing system. What tended to happen in May issue jurisdictions is that famous people, security guards, retired police, their friends and their family, politicians, and people willing to pay bribes got permits while others didn't. Um, Not all major issue jurisdictions were like this. Connecticut and Delaware, for example, issue on what's essentially a shall issue basis. So that left 6 states that required a special need: all of Hawaii, all of New Jersey, um, uh, and all of Maryland, plus parts of New York, California, and Massachusetts. Um, so the big questions in Bruen were one, of course, was whether a May issue licensing regime is okay or not. Also, whether means-end scrutiny would apply per the two-part test. And second, what history mattered and what didn't matter per the first part of the two-part test. So Bruen comes down, and the core rule we get from Bruen is that discretion in who can exercise the Second Amendment right is not allowed. There's a poignant quote in the case: "We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need." Um, Means-end scrutiny and the two-part test, both are also gone. Judicial interest balancing is not allowed, and the judiciary may not defer to legislative interest balancing either. Um, Relatedly, as is supposed to be the case, once a rights asserting plaintiff makes a prima facie case, the burden of proof is on the government. And so I'll just make a comment here, and again, this will be relevant later. I think this all turned out the way it did because lower courts were so brutally abusing means-end scrutiny to uphold gun regulations, to uphold just about every regulation that came their way. Had they applied heightened scrutiny in a meaningful way, the construct may have survived in the Second Amendment space. But the court, seeing what happened, struck it. So, in other words, this is the Supreme Court asserting its authority. Say, hey, you're not doing what we told you you're supposed to do. So the core test in Bruen is text as informed by history. Bruen is often seen as being in two steps. Some people call it three. Some say there's a step 1.5, and so on. But typically, step one in Bruen is that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And that's not all that unusual, though. Again, this is something we'll talk about later today. Let's say a defendant asserts a Fourth Amendment defense on the ground that the police officer was staring at me while I was having lunch in a restaurant. Well, he wouldn't have a Fourth Amendment claim because staring at a person in a public place is not a search or a seizure, right? Um, then at step two in Bruen, so once the Second Amendment's plain text is implicated, the government has to justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation. As to what historical tradition matters most, the court went through several eras. The important thing to know for us today is that the founding era is important, and very likely the second founding or the Reconstruction era, where the Reconstruction amendments were passed, is also quite important. And in the Carey cases so far, it hasn't mattered, and it probably doesn't matter too much in this case either. But know that those are the two eras that really matter. And then how do you apply this history? Well, you do it by analogy. And the Bruen Court goes into this in some detail. One might ask why, and I think that it's an attempt to head off more defiance of Heller and MacDonald, which incorporated Heller against the states. The court laid out basic, what you might call 1L rules of analogizing, which it shouldn't have had to were it not for the abuse of the two-part test that we discussed just a couple of minutes ago. The court referred specifically to, quote, at least two metrics for analogizing. Quote, how and why the regulations burden a law-abiding citizen's right to armed self-defense. How means, quote, whether modern and historical regulations impose a comparable burden on the right to armed self-defense. And why means whether that burden, quote, whether that burden is comparably justified. And these two, Bruen's how and why, you'll hear them referred to that way, come up all the time in Second Amendment opinions, and they came up in oral arguments as well. I've argued in some scholarship, to which I'll throw the site out later at the appropriate time, albeit in a footnote, that I think the other all members of the five W's are relevant here, but these are the ones that come up the most and that Bruen explicitly mentioned. So after Bruen and before Wolford, we had Rahimi in 2025, a man under a domestic violence restraining order, who shot at his girlfriend. He went to Whataburger and didn't like the way the burger came out, so he started shooting in the air. Was indicted for possessing a firearm, and the Supreme Court upheld his conviction. So kind of not surprising there. What was surprising there is the Fifth Circuit's reversing his conviction. It was an 8-1 opinion, Justice Thomas dissenting, saying that the government hadn't met its burden there. Not overly relevant for us today, but I put that out there in case anyone would like to discuss it. There's some interesting things that come out of that case as well. Bruen has had some positive effects on defiance if you look at pre and post Bruen studies. But in 5 of the 6 states, defiance continued, this time rather than the courts, with the legislatures leading the charge. And so this is kind of our lead up to Wolford here. It all started in New York, which passed the Concealed Carry Improvement Act, and that Concealed Carry Improvement Act was copied by Hawaii and all but Massachusetts of the states that I mentioned. So Massachusetts, to its credit, did not adopt one of these clones of the Concealed Carry Improvement Act. The CCIA. So the CCIA was passed after New York's governor sent what's called a message of necessity under New York's Constitution to avoid the state constitutional requirement that the legislature and the public, by the way, must have 3 days to deliberate over proposed legislation before it can be voted on. The governor and many legislators said that this law was too urgent not to pass immediately. I thought that was an odd claim, given that the law wouldn't take effect for another 2 months. Um, when a reporter asked, quote, "Do you have the numbers to show that it's the concealed carry permit holders that are committing crimes?" The governor, replied, quote, "I don't need to have numbers. I don't have to have a data point to say this is going to matter." When asked where permit holders would be allowed to carry, she replied, and this is important, quote, "Probably some streets," end quote. Um, that law, including Hawaii's version of it, which is what's being challenged here, contains a sprawling list of restricted locations, and it's made up of a combination of the sensitive places, so-called sensitive places that I mentioned earlier when quoting Heller, and what's come to be known colloquially as the vampire rule. Um, that provision bans carry on private property, including property open to the public, without the owner's explicit permission. Um, Bringing a gun into any building is a felony, is a felony unless the owner posts a permission sign or verbally grants express permission. Um, it came to be called as the vampire rule because in folklore, vampires could only enter one's property if invited in. And so the idea here is that the law is treating concealed carry permit holders as vampires. The rule started in a 2020 Law Review article. Before that, there was no sort of notion of requiring affirmative consent. We'll get to that point in a little earlier, but for now, just be aware that the idea wasn't even on the table until 2020. Under the law, all one can practically do is leave home, spend time on the streets, and go back home. So you can't stop for gas. You can't go to the bathroom. You can't enter a store where you might want to buy, if you're running an errand, you can't enter the store in which you need to buy something, and so on. Um, so every case that had addressed the vampire rule or the Concealed Carry Improvement Act had upheld various aspects of the act and stricken others, but all of them had stricken the vampire rule, and that changed when the Ninth Circuit upheld Hawaii's vampire rule. Okay, that brings us to Wolford. Wolford challenged Hawaii's vampire rule. Um, I'll cover the main points discussed at oral argument, including what each party and the salient things that the justices said. That, of course, may portend parts of the outcome or the outcome, but I'm not one to read any Supreme Court tea leaves. So I won't be, at least I'll attempt not to make any predictions on what the case will look like. I'll attempt to cover the topics in a logical order, but you'll see that there's overlap between the topics, and one argument depends on another, or at least is strengthened by the other, or kind of leads into the other, and so on. So the first I think actually literally the first question that came up in the case was a question about property open to the public versus property closed to the public. And there was a fair amount of questioning about, in effect, what property is open, right? What property is open to concealed carry license holders? And the things that were at the edge of this, everyone more or less agreed that when we're talking about a store, for example, or a restaurant that's truly open to the public, in the way of a public accommodation, certainly we were talking about that. But how would this rule apply? How would the vampire rule apply to private residences, right? If a friend invites you over for dinner, do you have to get that friend's explicit permission? Or what about the walkway up to the front door, right? What if you're leafleting and you want to drop a leaflet in somebody's mail slot? Can you do that? Can you walk from the sidewalk to the mail slot with a firearm concealed on your person? And these were the kinds of questions that came up. In my mind, for the most part, these seem to be much ado about nothing. For now, I'll just say that most of these situations involve an opening of the property, right? So all of the assumptions in all of these involved an opening of the property to the potential gun carrier. Unless, of course, we're talking about burglary, in which case one is already trespassing and you can't have a firearm and you're already guilty of trespass. And by the way, you're guilty of burglary and there may be some enhancements for having a firearm and so on. So those aren't the cases we're talking about. That was a bit muddled up at oral argument, but I think distilling it this way kind of gets us to the point. There was plenty of talk about First Amendment analogies in this context. I think some combination of these will likely make it into the court's analysis or analyses if we have multiple opinions. These First Amendment cases to which the court was analogizing to or borrowing ideas from can be somewhat contradictory, and I suspect whatever opinions we get, we'll have to pick and choose which one to follow. So, for example, there are laws saying that it's okay to bar leafleting in a neighborhood or in a shopping center unless the owners opt in, and there's another case that I recall that it's okay that it's not okay for you to opt out of mail on certain it's not okay to get mail on certain topics unless you opt in, right? So these there are cases out there and they seem to be somewhat contradictory, and I think the parties were certainly, choosing them in ways that made sense for them, and I suspect if they show up in the opinions, then the justices will do the same. Um, Now, the first sort of big question here, or big area of debate here, or big issue, is whether this is a property case or whether it's a Second Amendment case. Petitioner, of course, filed its lawsuit and said this was a Second Amendment case about carrying in public, and as Bruen says, Bruen is a case about carrying in public. And especially that's the case because it so greatly impacts the ability to carry in public. Um, the respondent said it's actually a property law case that deals with consent to enter property and that the definition of consent varies from state to state. And we're not touching the Second Amendment right here. And I'll read you some poignant quotes or defining quotes on that topic from both sides. And the United States was given time to argue here. It filed an amicus brief and it agreed with the petitioner here. And so the first question is whether this question of an express versus an implicit consent to enter the property, right? Everyone agrees that excuse me, that a property owner could deny consent to enter his or her property with a firearm. The question is whether someone opening to another is given consent automatically, or at least that's how the respondent tried to frame this. The rule everywhere until Bruen, including in Hawaii and the other four states with respect to those holding may issue permits, was that inviting someone onto property includes permission to do normal things that normal people do, right? Um, in the US, where we have a Second Amendment, that's a fundamental right that potentially includes a firearm. The owner can, of course, ask otherwise, just as the owner can ask, for example, that no swearing take place on the property, right? Um, Justice Jackson asked about this topic a lot, right? Is this just a question of who's granting consent? Justice Barrett and Justice Sotomayor also showed quite a bit of interest on this topic. Um, the respondent, Justice Jackson, here's a quote from Justice Jackson. I'm suggesting that the Second Amendment is not being implicated when the regulation is about the property owner's consent, right? Or implicit consent in this case. Um, Justice Sotomayor said that flipping the presumption didn't impact the Second Amendment right. One can still carry if there was consent, and this case is about how that consent is determined. And in this case, it's determined by the legislature requiring explicit consent instead of implicit consent that existed until now in the entire country and exists in, the other 45 or 46 states, right? the respondent here, Hawaii, you'll hear me say respondent and Hawaii somewhat interchangeably here, pointed to a bunch of other modern day laws in which presumptions were flipped. But it's worth noting here, and none of the justices really mentioned this, the the uh, the Solicitor General's office did mention it, the U.S. did mention it, albeit somewhat a little bit indirectly. Most of these didn't deal with constitutional rights on the other end. So there were presumptions about whether you can remove shopping carts from a premises, for example. Well, obviously, that's got no constitutional component here. That's got no constitutional implication at stake. Um, the United States pointed out, here's the quote I was just referring to, that quote, trying to redefine property rights doesn't take them out of constitutional scrutiny, end quote, when that redefinition impacts constitutional rights. And so this question of express or implicit consent, especially if we're sort of looking at this as a property case, then became a question according to the respondent. And the respondent did a great job of trying to frame the case here of whether we're looking at local tradition or some kind of national tradition or national understanding. And this question matters, Hawaii said, because making it a property case means that because Hawaii had no public carry for 200 years, there's no implicit consent that the owner, quote, wants guns on his property, or that, quote, every invitation to enter private property includes an invitation to bring a gun. That's a bit of hyperbole there. That's not really what's at issue here. It's not quite right to suggest that the two choices on the table are an affirmative invitation to bring a gun onto property under the traditional rule that the countries had until the vampire rule was enacted, or a refusal to allow guns, which the vampire rule is suggesting. Refusal unless explicit permission is given. That the respondents counsel is sort of going a little bit past what's really at issue here. But the respondent also argues here that the legislature is free to change a default property rule. Of course, the legislature is not free to change a constitutional rule, and so you can get a sense of the different ways in which calling this a property rule benefits Hawaii, right? And why the strategic choice was made to refer to this as a property rule. The petitioner and the Solicitor General's office says that this is a constitutional case, and that there's one Second Amendment, not a different Second Amendment that works differently in each state. We can't have one Second Amendment in Hawaii where there's one tradition and one in Wyoming, where I am, that has another tradition with respect to firearms. Right? So I'm editorializing a bit here, but I think they can be seen as saying that by the U.S. and the petitioner can be seen as arguing that buying into a national polity in which the Constitution guarantees certain rights means having to respect those rights. Hawaii doesn't get a veto based on its traditions. And Justice Sotomayor was especially interested in this 200-year part and the tradition part. She asked about Hawaii's 200 years of the 200 years of Hawaii's customs, tradition, and culture, right? And that to her was a rather big deal. So another big question that came up here was, and you can already see these are starting to intertwine the questions, and well, that's not stopping, was which step of Bruen's framework are we at in this case, right? Bruen notes, remember that Bruen said that if the Second Amendment's text covers the conduct at issue, then the burden is on the government to justify its regulation by the history and tradition of firearms regulation in the country, right? The petitioner here says that Bruen was about public carry, and I'm quoting Bruen here, and carrying in public, also quoting Bruen. So we clearly implicate the Second Amendment, which protects the right to carry in public. And so Bruen's step 2, where the government has to justify the law in question under history and tradition applies. Respondent says a couple of things, um, which boil down to saying that, look, we should be at step one here. So part of that is saying that this is a property case, and part of that is saying that if this is a Second Amendment case, we have to look at it a little bit differently. Part of it is looking at the history and tradition of property law, and the argument is very smooth. So let's go through it here, right? So respondent doesn't believe that any case involving guns automatically goes to Bruen step two, right, where the burden is shifted to the government. Um, Bruen, I'll read you what it says that, quote, when the Second Amendment's plain text covers an individual's conduct, excuse me, the Constitution presumptively protects that conduct. And you go on to step two, where the history and tradition of regulation enters in to see whether the challenge law is valid. But the respondent here says, no, history and tradition actually comes into the picture at step one. So the inquiry shouldn't be whether the right to bear arms is impacted. Remember, bear means carry, right? But rather, whether there's a Second Amendment right to bring your gun onto someone else's property without consent. I don't have quotation marks in front of me here, but I believe that's actually a quote from either from the arguments or from Hawaii's brief. You don't, whether there's a Second Amendment right to bring your gun onto someone else's property without consent. If it's not a direct quote, it's very close. Now, notice that this avoids entirely the troublesome issue of seeing whether government can regulate by flipping burdens, as Hawaii did. And the same history and tradition that you use at step two is the history and tradition that you look at in step one to determine whether you get to step two. Now, remember, I mentioned some circularity earlier. Here it is again in a different form. And Hawaii says that the petitioner hasn't shown any evidence that a statute flipping a property presumption is problematic. Now it's it's sliding in the property aspect of it. Even though Bruen says that the absence of a kind of regulation is good evidence that it's in fact problematic. So we can guess that this is why the property aspect is being slipped in here, because Bruen is about the Second Amendment, right? So it's making here Hawaii's counsel is trying to flip the burden back by kind of mixing different aspects and different areas of law together on different tests to get to a result where there's no burden being flipped, where the petitioner hasn't made a prima facie case, and therefore there's a presumption that the challenge law is valid. He made lots of talk about rational basis, how we might have rational basis problems in some cases, but not here. He even says here, quote, we just fundamentally disagree that this burdens firearms, end quote. And then he adds that even if it does burden firearms, Bruen rejects an interest balancing inquiry. He doesn't mention there that the interest balancing inquiry that Bruen rejects is balancing a government interest against the Second Amendment right under heightened scrutiny, right? Rather than just the interest of a rights holder wanting to exercise his or her rights, right? So he's very smooth about it. Actually, it's masterful. Biting on this means that a property history means that it's a property history and tradition case rather than a Second Amendment case. And Second Amendment cases, of course, under Bruen are supposed to be history and tradition. And making it a property case has the implications that we already discussed, right? And as a bonus, you've got all this property history and tradition on your side, maybe, right? Justices Kavanaugh, Kagan, and Barrett call him out on this point. To his credit, he had Hawaii's attorney had an exceedingly difficult case to make here, and he did a great job making the most of what he had to work with, right? Even if in the final analysis, one can be skeptical about it. So what about the analogs, right? What about the analogs that we're supposed to look at when determining whether there's a history and tradition of regulating a kind of conduct, right? Are they relevantly similar? That's language from Bruen. Um, and there was a lot of action around statutes requiring permission by the owner for people to enter improved or enclosed lands with a firearm. Um, these statutes have long been recognized by people in this field and lower courts addressing Second Amendment questions as anti-poaching laws. Most, maybe all, the justices who asked about them treated them as anti-poaching laws. The petitioner and the United States agreed that they were anti-poaching laws. Um, the statutes were designed to prevent trespassing, and trespassing even shows up in some of them. Um, but as we said, we're not dealing with trespass situations here. We're not dealing with an armed burglary, for example, right? We're dealing with invitations of one kind or another onto property. Um, the petitioner pointed out that the statutes, by their terms, only applied to lands closed to the public and that they didn't bar carry for self-defense. I think that's right. The United States says that the relevant comparator, right, the relevant historical analog is property open to the public, right? Again, think public accommodations. Think in that, generally speaking, in that category, stores, gas stations, whatever, right? The respondent here, Hawaii, said, citing an amicus brief, that these actually applied to land with businesses and buildings on them. Somewhat of a novel argument. The United States disagreed. It cited a brief on which I'm co-counsel, saying that, quote, it would have been profoundly disturbing to the founding generation to hear that travel to inns or taverns or anywhere else people commonly carried arms, that they had to get affirmative consent and hope they weren't trespassing, right? And be subject to felony prosecution and conviction because that's the penalty under this law. If you carry onto private property without getting the consent required, you've committed a felony. Not surprisingly, as I said, I'm co-counsel on a brief that the U.S. cited for this proposition. This sounds right to me. Taverns were these community centers where the government regulated many things: prices, excessive drinking, curfews. The tavern itself was licensed, right? Showing that the government was actively regulating in the space. But never arms carriage. Arms carriage was never regulated there. It was common for taverns to have hooks to hang firearms. They held various kinds of shooting games, target shooting and bird shoots and these kinds of things. Churches never had arms regulation, and sometimes carriage was mandatory there. The same combination on public assemblies. Weddings and funerals, ballrooms, shops while working, all none of those had laws against armed carriage, and we document that arms carriage was in fact very popular at these places. It's also worth noting that arms carriage was a routine part of travel, and travelers were necessarily dependent on establishments open to the public, right? They had to eat. They had to stop at an inn and sleep and so on. Some interesting questioning on this point came from Justice Kagan, who agreed that they were anti-poaching laws and that Hawaii's was not. But she said that nonetheless, she thought they were relevantly similar under Bruen. Again, relevantly similar is a phrase from Bruen. For her, it was enough, quote, that there's a danger of various injuries when you go onto private property with a gun. It might be poaching then, and the property owners feeling good about not having guns around on property now. And that's the stated reason for the vampire rules passage, right? Just kind of the property owners warm and fuzzies here. Um, she explicitly said that abstracting up like this to general thoughts of harm was okay. The petitioner and the government, the U.S., noted that this would also seem that this would seem to be an improper abstraction to so high a level of generality that it swallows the rule. A self-plug here, I agree with that point, and I wrote about abstracting too high in these kinds of cases in the young adult context. If you're interested, the site is 103 WashU LRev Online 100, where I talk about, at least I offer one way of abstracting properly. Another thing discussed a lot were the black codes. These were post-war laws denying people of color many rights, including things like contract and the right to keep and bear arms. The respondent, Hawaii, relied on one from 1865 Louisiana to support its case, calling it a dead ringer to the Hawaii law. It did say at oral argument that although this was part of a larger racist black code, and there were several of these in the post-war South, the facially racist parts were repealed from the law before Louisiana was admitted to the Union, and that this part was therefore okay. That argument, though, wasn't in its brief. It also argued that this law actually protected black churches and businesses, because then racists couldn't bring firearms into those establishments. Remarkably, Justice Jackson found these to provide strong support for Hawaii's law. She said that disregarding black codes undermines the Bruen test's accuracy, and that it would ignore a part of history that even bad history counts. So understand this. Under this reasoning, the actual black code, the actual 1965 Louisiana law, with its explicitly racist language, would be acceptable today, right? The U.S. replied that the black codes were unconstitutional ab initio, and in any event, they were outliers, which Bruen and Rahimi make clear can't form a tradition. Justice Gorsuch did some questioning on that point about them being outliers. I think that's right as a definitional matter, right? Um, Tradition should have something of a public understanding in it. Um, uh, Justice Jackson disagreed, saying that the laws, even laws like the Black Codes, were unconstitutional until declared otherwise. Um, all of this I find to be somewhat bizarre, I have to confess. First, it's a strange notion that an unconstitutional law passed for statedly unconstitutional reasons can form part of the history and tradition supporting a law's constitutionality. Um, Second, and relatedly, it fails Bruin's test in as much as a historical law passed for an illegitimate reason is necessarily passed for a different why. Remember Bruin's why, how and why. It's necessarily passed for a different why than a modern challenge law that respondents argue is passed for a legitimate reason, right? Third, the black codes applied to those not considered to be part of, by some, to be part of the national polity. That might explain, presumably that explains why legislatures felt comfortable passing them. But equal protection doctrines thankfully deal with that issue. And in any event, Hawaii's permit holders are exceedingly law-abiding and clearly part of the people and not criminals and they're protected by the Second Amendment. Um, Rahimi also said that historical laws that characterize disfavored groups as dangerous for the purpose of disarming them were not proper grounds for disarming people today. The U.S. made that point most directly, that Hawaii's law is saying that certain disfavored people, concealed carry license holders, normal people doing something normal, are Hawaii's disfavored people. Um, Gorsuch asked why this didn't apply to knives and other things. And to this, the respondent just replied that there's no equal protection component in the Second Amendment like there is in the First Amendment, right? With the First Amendment, for example, there's viewpoint discrimination. So under this logic, again, a modern black code targeting the right to keep and bear arms would indeed seem to be perfectly constitutional. And the notion that the law protected black establishments, churches and restaurants and so on, businesses and so on, is at odds with the stated reasons for the law's passage, and more importantly, the reality that white racists terrorized freedmen with impunity in the postbellum South. This law existed to make it easier for the postbellum legal apparatus to oppress black people. Okay. Um, uh, the next point, this one was made by the government. The next point that had a lot of conversation at oral arguments. The U.S. argued that, quote, pretextual regulations are by definition unconstitutional, and that Hawaii's law by its terms undermines Hawaii's claim to protect property rights. It gets to Bruen in that there's no permissible why here. Kind of CF, the black code discussion we just had. An example from the US's brief talks about an exemption for police officers, off-duty police officers, retired police officers, and out-of-state police officers. This argument, the first time I saw it, it was made by Professor Robert Leiter, who's actually working at the ATF now. If Hawaii's vampire rule were really about respecting the rights of property owners and allowing them to make quote unquote informed decisions about guns on their property, then all situations that didn't involve a justified trespass, a police officer responding to a situation, would require the property owner's permission. Um, if this were really about property owners' wishes not to have guns on their property, then certainly off-duty police, retired police, and out-of-state police would not be exempted from the affirmative consent requirement, but they are, right? If you fall into one of these categories, you can walk onto any property without having to get affirmative consent. The same would apply to on-duty police stopping into lunch, for example, if this were really about, the warm and fuzzies of someone not wanting firearms on property. Um, the US's brief also talks about how the idea to flip the default rule originated in that 2020 law review article. There was the law review article, and then there were a couple of other smaller pieces, op-ed type pieces. Um, the stated purposes of the article were to make it inconvenient to travel freely with firearms. Um, the government, the Solicitor General's office, also noted that a large motivator for the Second Amendment's passage way back when, in 1791, was the history of their English game laws, with their pretextual income and land ownership requirements used to disarm commoners. I did some research in that space at some point, and the modern equivalent of the income requirement, just the income part, never mind the land part, at times was over $200,000 today. Right? Um, this is all somewhat reminiscent. The original English game laws, especially enacted by the Stuart monarchs, but not just them, to disarm the commoners, to disarm the people they didn't want to be armed, the rabble, right? Is somewhat reminiscent of the supposed 200 years of Hawaiians' custom of gunlessness, right? The great majority of which was forced onto them by a monarch, the King of Hawaii, before Hawaii became a state. Um, Justice Kagan here replied that constitutional law doesn't judge motive directly, and that was actually a point that the Solicitor General's brief acknowledges. And so the U.S. here repeated that this isn't about reading legislatures' minds, but about looking at the law's design, operation, and enforcement. That's a quote from the brief, to see whether it's consistent with the legislative objective. And various aspects of the law, like the law enforcement exemption and so on, suggest that it's not really about the law's stated objectives. A couple of other concerns, and this is just worth noting, and it gets back to the defiance of Heller that we talked about earlier. Justices Roberts and Alito asked about the Second Amendment being treated as a second-class right, and how that was obviously a concern for the court. And I think that vindicates or supports the notion that the heightened scrutiny is not part of Second Amendment jurisprudence because of all the defiance that was taking on. So I'll close here with a quote from Professor Mike O'Shea, my friend and co-author at Oklahoma City Law. And here's what he says about the CCIA in general and the vampire rule specifically. Quote, "The law is an affront to practical reason. If this is a genuine effort to comply with Bruen, they're doing law wrong." And I think that encapsulates things quite well. And so with that, I'll say thank you very much and maybe welcome a few questions if we have time.
Wonderful. That was a great summary and analysis of what we heard in oral arguments. Thank you, Professor. We'd now like to open the floor for audience questions, which you can submit through the Q&A box at the bottom of your screen. Just please make sure that they do end in a question mark and pertain to the topic at hand. Just to start things off while we wait for everyone's submissions, some of these states that have, stricter laws like California and New York allow relatively more liberal public carry in more rural areas. How do these laws, if they're not stricken by the courts, affect people in the more rural areas? How would you say?
Very good question. And that gets to what you might call an irony an irony inherent in Bruen or Bruen combined with the laws afterwards. So as the questioner asks or notes, in in Massachusetts, California, and New York, um, in most of the state, the sheriffs who issue the licenses would effectively do so on a shall issue basis. So that means if you're not a criminal, if you're not insane, if you've taken a safety course, you have to be issued a license. So those states were may issue states where the sheriffs or the issuing authorities had the discretion not to issue licenses, but generally they issued them. So there are a couple of interesting maps out there. I've seen ones of New York and California, where if you look at, say, New York City and Long Island is red, and so is an area kind of probably around Syracuse, or maybe Albany as well,
Yeah.
where you can't really get a license, but the rest of it is green, and there are different
Mm.
shades of red and green, right? And so in almost all of the state, you can get a license. Before Bruen, you can get a license, or before the CCIA was enacted, you can get a license. Same thing in California. The overwhelming majority of the state, by territory at least, was able to get a license, even in something like San Diego, right? So
Mm.
Los Angeles was more difficult, and San Francisco was basically impossible. Now, if the CCIAs stand, and especially if the vampire rule stands, right, then all of these people who before Bruen, which was supposed to vindicate the Second Amendment right to carry in public, if the vampire rule stands, those people will now effectively not be able to carry in public. And that's a great irony. And one would hope that the Supreme Court recognizes that and sees that, look, if this is allowed to stand, what we said is okay in Bruen is not actually going to be okay in these states.
Absolutely. We have one audience question that asks, where do you see the sensitive places doctrine going? I know that that was discussed at oral argument a bit. So if you could touch on that.
Yeah, yeah. I think of the sensitive places doctrine as kind of the brother, or at least the cousin of the vampire rule. I think of the vampire rule as this gigantic, all-encompassing sensitive places doctrine.
Hmm.
The sensitive places doctrine says that in certain places, certain sensitive places, like polling places, for example, right?
Yeah.
You're not allowed to carry firearms. I think as, a high-level abstract matter, I think the doctrine will stay. Um, some the states that pass these laws
Yeah.
also passed a relatively broad range of sensitive places, right? So New York, for example, said that Times Square was a sensitive place. And
Hmm.
it wasn't just Times Square as we think about it, kind of where Broadway and Columbus come together, and for a few
Yeah.
blocks going up, I'm a native New Yorker. But this large area encompassing, I'm estimating now based on seeing the picture from
Hmm.
memory, 12, 15, 20 square blocks, something like that, right?
Yeah.
Um, I think, and Justice Thomas did say in one of his opinions that you can't make all of Manhattan a sensitive place. So Times Square is
Right.
not all of Manhattan, but if you include public transit, then it's starting to feel like it is. So I think the doctrine will be around. I think legislatures in these hostile states will try and use it to restrict the carry right. There have been some that have been stricken. Courts have been, after Bruen, have been better in striking them. They haven't been perfect. I think there still is some judicial defiance of Heller going on, and
Hmm.
Bruen, I suppose I should add. Um, but I think they are striking more of these rules, and I think they would be striking more were it not for some defiance. But Bruen is having a good effect on these.
Yeah. All right, we have another question about whether the basis for incorporation of the Second Amendment against the states, privileges or immunities clause versus the due process clause, Does that have practical implications for the scope of a ruling striking down the Hawaii statute?
Oh, for scope of a ruling striking the Hawaii statute. Um, so So a couple of questions there. Just to give the background. So Heller
Mhm.
said the Second Amendment protects an individual right to keep and bear arms. McDonald incorporated that against the states. It was a 5-4 opinion. Four justices incorporated under the substantive due process clause or the due process clause, so under
Mhm.
substantive due process.
Yeah.
And Justice Thomas wrote separately agreeing with the majority and in the result, but saying that it really should have been under privileges and immunities, the privileges and immunities clause of the
Mhm.
14th Amendment. And there's been some discussion there about whether maybe privileges and immunities provides more protection in some situations. And Justice Thomas at oral argument, actually, there are one or two sentences in oral argument where Justice Thomas asks one of the parties, I don't recall now whether
Mhm.
it was the petitioner, the government, or the respondent, um, uh, a question, and he refers back to quote my opinion in McDonald, where he said he incorporated under the Privileges and Immunities Clause, and he made a remark about how that might be especially well suited to protecting the kind of conduct at issue in this case. Um, he may be right there, right? Privileges and immunities
Yeah.
talks about rights and, rights is, how do we define rights? Is it constitutional rights? Is it statutory rights? Is it, ordinary rights of citizens? Um, so there, at least if nothing else, I can say there was an indication that Justice Thomas thought that this would be the P&I clause was especially good grounds for protecting this kind of conduct, right? The right to
Mhm.
enter a place
Yeah.
open to the public with a lawfully carried firearm.
Yeah. All right. We have time for one more question. If one could show that sensitive areas have no lower crime rates than other non-regulated areas, could one argue that such restrictions lack a rational basis and are therefore invalid? It's
Hmm.
kind of interesting.
Yeah, interesting question. So there are two conflicting things there as I'm thinking aloud through
Yeah.
this. So the Supreme Court Second Amendment jurisprudence makes clear that, just like, for example, with the exclusionary rule, where we're not counting, we're not looking at social science here, right? Um,
Yeah.
because when we're talking about a right, despite what some folks and some respected colleagues in the field say, um, rights do trump these kinds of considerations, right? It means that no matter how good we think it is, no matter how much we like it, um, the right controls. And
Mhm.
we see that in the exclusionary rule, where criminals have been let go and went on to commit crime again, sometimes pretty bad crimes, right? So that's one aspect of it. That would seem to militate, even though it's coming at it from the other direction, in favor of that not really mattering, right?
Yeah.
On the other hand, the rational basis question is this sort of general overarching question about laws in general, right? As I mentioned, the respondent referred to this,
Mhm.
Hawaii's counsel referred to this, saying, uh, if there's no rational basis and he was talking about this in the context of the First Amendment analogies and comparing it to the Second
Mhm.
Amendment. If there's no rational basis for a law, then it fails. And I think it is fair to say if there's no rational basis for a law, then it's not constitutional.
Yeah.
So there may be something there, right? But I think the empirics question complicates it a little bit, right?
Yeah.
But maybe if you can find maybe if everyone agreed that guns are not in this given type of sensitive place didn't matter, maybe there's
Yeah.
something there. But they'll find somebody, the government defending the law will find somebody to say that well, actually, here's this little blip and that's what we think and so
Yeah.
on. So,
Well, wonderful. Thank you so much, Professor, for joining us today and for sharing your expertise and insights on this really fascinating case. Thank you to our audience for submitting your insightful questions. If our audience is interested in learning more about all of our programming here at the Federalist Society, please visit our website at fedsoc.org or feel free to send us your feedback. We always love to hear it at fedsocforums@fedsoc.org. Thank you so much. We are adjourned.